Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. One major issue in the National Capital Region for the past few days has been the morning sun struggling to pierce through the thick veil of pollution, and the people waking up to a city battling the relentless grasp of smog. In an important update, the Supreme Court today sternly directed the governments of Punjab, Rajasthan and Haryana to take immediate steps to stop stubble burning by farmers in the state, which the court said was one of the major contributors to air pollution. The bench comprising Justices Sanjay Kishan Kaul and Sudhanshu Dhulia directed for a meeting to be held tomorrow between the states of Punjab, Haryana, Uttar Pradesh and Rajasthan to ensure that crop burning is stopped forthwith. The court also directed the Delhi government to ensure that municipal solid waste is not burnt in the city during the open as it happens, and asked the government to repair the smog towers. The court also questioned the effectiveness of Delhi government's odd-even scheme in controlling air pollution while terming it as optics. While agreeing that steps are necessary to stop crop burning, the Advocate General of Punjab said that farmers were burning the stubble on account of economic reasons. He suggested that the centre provide subsidies to provide the required facilities. He also suggested that paddy cultivation must be phased out to be substituted with other crops, and the centre must explore the options for giving minimum support price for other crops rather than for paddy. The court will now hear the matter on coming Friday to monitor the progress. Coming to another important update, the Supreme Court bench comprising Justices Sanjay Kishan Kaul and Sudhanshu Dhulia was today hearing a petition filed by Advocates Association of Bengaluru seeking contempt action against the Union Ministry of Law and Justice for not adhering to the timeline set by the court in 2021 for clearing collegium proposals. In September, the court had reiterated its apprehensions to the Attorney General over the government's delay in clearing the names or notifying the recommendations made by High Court collegiums and the Supreme Court collegium. On the last occasion, positive developments with respect to judicial appointments were commended in view of the slew of appointments and transfers of High Court judges notified by the central government. Today, the Apex Court again expressed disapproval of the pick and choose approach adopted by the central government in selectively accepting names from the collegium resolutions for judges' appointments. The court also conveyed its concerns to the Attorney General R. Venkataramani about certain proposals made by the collegium for transfer of High Court judges pending with the central government. Citing an example from Punjab and Haryana High Court, Justice Kaul orally deprecated the centre's practice of segregation of collegium recommendations. He said, while the Supreme Court collegium had recommended the elevation of 5 advocates as the judges of Punjab and Haryana High Court, centre only cleared 3 names, ignoring the names placed in serial numbers 1 and 2. He said that several recent appointments made by the centre reflected this trend. Though the bench did appreciate the progress in the judicial appointments over the last 2 weeks following the monitoring by the court, it also said if the appointments are done in a selective manner, it will disturb the inter se seniority, making it hardly conducive to pursue young lawyers to join the bench. The Attorney General R. Venkataramani assured the court that he would take up the matter with the government. The bench posted the matter for next hearing on 20th November. The Supreme Court has expressed concerns over the arbitrary seizure of media professionals' digital devices and stressed the need for better guidelines to protect their interests. A bench of Justices Sanjay Kishan Kaul and Sudhanshu Dhulia was hearing a PIL filed by the Foundation for Media Professionals, a society of journalists, urging the court to establish safeguards against unreasonable interference by law enforcement agencies. The foundation has sought comprehensive guidelines for search and seizure of digital devices. The foundation has highlighted the increasing reliance on personal digital devices by its members for their journalistic work, which often involves handling confidential information of public value, private correspondence with sources and whistleblowers, and remote collaboration to break news stories in the public interest. Recently, a group of media organizations in the wake of raids of journalists associated with NewsClick had also written to the Chief Justice of India seeking guidelines on seizure of digital devices. The Additional Solicitor General S.V. Raju today requested for some time to better examine the matter so that he can make submissions. The court said that there has to be balancing of interests and proper guidelines need to be in place to protect the interests of media professionals. The hearing will continue on 6th December. And now a brief update on the Adani-Hindenburg case. As you know that a group of PILs had been filed in the Supreme Court seeking a court-monitored probe in the allegations against the Adani Group of widespread manipulations and malpractices aimed at inflating its stock prices. In March, the Supreme Court had constituted a committee to investigate the allegations, directing it to submit its report within 2 months. The petitioner had filed an affidavit in the Supreme Court raising apprehensions about the neutrality of the members of this committee. At the same time, SEBI continued its investigation into the securities markets volatility in India. SEBI was also granted extension twice to submit its report. The case was then scheduled to be listed on 29th August, but as of today, it has not been listed for hearing. Now, Advocate Prashant Bhushan, appearing for one of the petitioners, mentioned the matter before the CJI, expressing concerns about repeated deferrals in listing the case. The CJI, acknowledging these concerns, stated that the court registrar would investigate the matter. The Supreme Court has deferred the hearing in the batch of petitions challenging constitutional validity of Section 6A of the Citizenship Act of 1955. This section was inserted by way of an amendment in 1985 in furtherance of the Assam Accord. The Assam Accord, signed on 15th August 1985, was a landmark agreement between the Government of India and leaders of the Assam movement. It aimed to address issues related to illegal immigration and protect the rights of indigenous population in the state of Assam, who had witnessed a significant influx of people from Bangladesh and other regions. It provided that the people who entered India between 1st January 1966 and 25th March 1971 and had been living in Assam would be allowed to register themselves as citizens of India. But Assam Sammalit Mahasangh, a Guwahati-based civil society organization, challenged this section in 2012. It argued that the section was discriminatory, arbitrary, and illegal insofar as it provided for different cutoff dates for regularizing illegal migrants who entered Assam and the rest of India. It sought the court's indulgence in directing the concerned authority to update the National Register of Citizens by taking account of the electoral rolls prior to 24th March 1971. Eventually, other organizations from Assam filed petitions challenging the validity of this section. A constitution bench was to commence hearing the matter from today, but Solicitor General Tushar Mehta sought deferment in the matter on behalf of the union and stated that he needed more time for preparation as he had just appeared before a constitution bench in a different matter 3 days ago, referring to the electoral bonds case. The SG also submitted that since this was the last week before the Diwali break, a lot of matters were expected to prop up and thus a constitution bench matter should be heard later. Though initially the CJI expressed difficulty in deferring and relisting a constitution bench matter, but upon insistence by the councils, he eventually agreed to defer the hearings. The matter has now been listed for 5th December. Stay tuned with livelaw. The District Consumer Disputes Redressal Commission Jodhpur bench in Rajasthan has held Zomato liable for the incorrect delivery of non-vegetarian food items to the complainant while he ordered vegetarian food items, causing him and his family mental and physical distress and hurting their religious sentiments. The complainant had placed an online order for McFlurry Oreo and Pizza McPuff from McDonald's through Zomato. Surprisingly, he received non-vegetarian food items. Allegedly, when he contacted Zomato through Twitter messages, they accepted the mistake and offered him food coupons as an inducement. Feeling aggrieved, he filed a consumer complaint. Zomato contended that it was merely a facilitator connecting customers to restaurants through its online platform, that it was not liable for the quality of goods sold by the restaurants and could not be held responsible for delivery of wrong food item. The District Commission noted that Zomato acknowledged their mistake when the complainant contacted them through Twitter messages. The Commission also highlighted that Zomato, as a facilitator connecting customers to restaurants through its online platform, had a duty to ensure the quality of goods sold and delivered by established standards. Thus, the bench ordered it to pay 1 lakh rupees to the complainant as compensation. A division bench of the Delhi High Court has disposed of a habeas corpus petition where a missing girl, a minor, was recovered, but her parents, who are the petitioners in the case, refused to take her custody in view of her pregnancy. Notably, the petition was filed by the mother of the girl seeking directions for her production before the court. It was alleged that a boy had lured the daughter away, established physical relations with her, and made public certain illicit videos that he had made of her. She informed the court that an FIR had been registered, but the police kept telling her that her daughter was enjoying family life with her husband. During the proceedings, standing counsel for the state appraised the court that the accused had been sent to judicial custody and the missing girl had been recovered and that she was pregnant by 6 weeks. The bench, comprising Justices Suresh Kumar Kaith and Shailendra Kaur, interacted with the recovered girl who was present in the court. During the interaction, the girl admitted that she was pregnant and expressed willingness to go with her parents. However, at this stage, her parents refused to take her with them. They explained their refusal by stating that it was not the first time that their daughter had been allured or was carrying pregnancy. The court then directed for the recovered girl to be taken to a women's shelter. And lastly, the Kerala High Court today took a stern view of film reviewers who were not registered under any organization nor accredited and also had no guidelines to follow while publishing their content on the online platform. Justice Devan Ramchandran was hearing a plea filed by Mubin Rauf, director of the movie Aroma Linde Adyate Pranayam, seeking a gag order to ensure that social media influencers and film reviewing vloggers do not publish any reviews of the film for at least 7 days following its release. The court went on to orally state that while persons expressing their opinions on newspapers and televisions were under some form of regulation or the other, no such regulations existed for those doing the same on online platforms. The court said that there were 2 kinds of reviews. One where individuals themselves start a YouTube channel to express their views, and another where platforms gave the right to rate movies or products. Both, according to the court, had to be dealt with in different ways. The counsel for the central government averred that the central government was looking into the issue and sought 2 weeks' time to file its response, which the court granted. Before adjourning the matter, Justice Ramchandran said that reviews are intended to inform and enlighten and not to destroy and extort. I hope you found this video informative and enjoyable. If you did, please consider giving it a thumbs up and sharing it with your friends. Don't forget to subscribe and hit that notification bell so you won't miss any of our future content. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.